Well, dear colleagues, it's a pleasure to be able to address you on a subject which underlines the statement yesterday made by several people about enforcement being the Achilles heel. I will begin just explaining what my daily work consists of very briefly. I've been working as an enforcement director at the National Enforcement Authority, specialized in matters having cross-border implications within the EU and the international treaty network, and insolvency matters related to the activities of this authority, which includes supervision in bankruptcy, the enforcement of private claims, as well as the enforcement of the public claims. I will begin with a brief introduction about the problem. The problem of insufficient transparency of the debtor's assets in civil and commercial enforcement matters having cross-border implications within the EU is the name of this topic. The treatment is limited to some aspects of access of information for enforcement purposes after a title of execution. I will treat this subject by making some comparisons with solutions in other parts of EU law, conventions and studies. And the purpose is to identify, evaluate and draw conclusions about possible ways of development and make suggestions for new EU law in order to improve this transparency in support of enforcement matters having namely cross-border implications in the areas covered by the scope of application of 4 EU regulations concerning civil and commercial matters. The 4 regulations here concerned are the Brussels I regulation, the European Enforcement Order for Uncontested Claims, the European Order for Payment Procedure, and the European Small Claims Procedure. This problem is of equal concern in relation to the 4 regulations mentioned here. The lack of efficient access to information for enforcement purposes in civil and commercial matters after a title of execution results not only in the national context but also in the cross-border context, in that the value of the title to a creditor is reduced only into a beautiful picture that he could put on his wall, while the debtor, despite of the title, actually still may continue undisturbed to dispose over and move his assets. Therefore, an improvement of the private creditor's problem of non-efficient access to lack of information for enforcement purposes about the debtor's assets for these purposes in the cross-border and national context in civil and commercial matters having cross-border implications is essential in support of securing the result of previous judicial procedures in the quality of titles of execution. The relatively low frequency use of the 4 regulations may likely, at least to some extent, be explained by the awareness of the creditor of the problem to obtain efficient access to information for enforcement purposes in matters having cross-border implications, both before and after he has obtained a title of execution. Therefore, if the creditor does not have access to any reliable information about the location of the debtor and his assets in other member states, he may not find it worth the time and efforts to obtain a title of execution falling under the regulations and instead write the claim off. This is not only, but in particular, likely in case when the creditor's claim concerns a minor amount. In order to address this problem of the creditor, the transparency of the debtor's assets has to be improved through efficient means in EU law, both in the cross-border and national context. No doubt, an improvement in EU law of the problem of transparency would stimulate creditors to make more frequent use of the four regulations here concerned. Also, if debtors become aware of an improved transparency about their assets in the EU, this may increase their willingness to pay both before and after a title of execution. I now intend to focus as brief as possible on three suggestions of improvement. The first suggestion relates to the new Brussels I regulation, the proposal, as just explained by my colleague here. The proposal for a new Brussels I regulation suggests that a more detailed and updated description of national rules and procedures concerning enforcement, including authorities competent for enforcement, information on any limitations on enforcement, in particular debtor protection rules and limitation of prescription periods, shall be included in the European Judicial Network in civil and commercial matters. And then I refer to Article 86 of the proposal. However, my conclusions in this context are that as a further step of improvement aiming at increase of efficiency, it should be contemplated that member states also should be obliged to make available to the network a description of the national information available for enforcement purposes, including any limitations. No doubt, I think this would be of some value to both the creditors and the legal professionals, but it's not sufficient to solve the creditor's problem on a practical level in matters having cross-border implications. Which leads to other suggestions. A EU system for exchange of information for enforcement purposes. There exist several arguments for the establishment in EU law of a new system for exchange of information for enforcement purposes between the member states. This is evident from the European Council's Tandem conclusions, the Council's Hague Programme, which foresees the possibility to develop an exchange of information between member states related to civil and commercial claims in enforcement matters by means of communication between the regulated enforcement agents in the member states for the benefit of the creditor. The European Council's Stockholm Programme emphasizes the importance to create a clear regulatory environment allowing small and medium enterprises in particular to take full advantage of the internal market so that they can grow and operate across borders as they do in their domestic market. The European Council has agreed to important elements of the European Commission's communication about a strategy for smart, sustainable and inclusive growth. The Commission's communication underlines the importance of a more competitive economy, the removal of remaining bottlenecks to cross-border activity that everyday business and citizens are faced with despite the legal existence of the single market, and that access for small and medium enterprises to the single market must be improved. A solution to the creditor's problem of having access to information for enforcement purposes in the cross-border context exists already in the maintenance regulation. This regulation includes some rather advanced provision on cooperation between central authorities as representatives for a creditor, which leaves an option for a private creditor to benefit from an exchange of information for the purpose to recover efficiently a maintenance claim on the access to information and or the notification of the information to the debtor. Another solution to the creditor's problem of having access to information for enforcement purposes in the cross-border context has been suggested in the recent proposal for a regulation of the European Parliament and of the Council creating a European account reservation order to facilitate cross-border debt recovery in civil and commercial matters. This proposal suggests to make it mandatory for financial institutions in the member states to provide information on the debtor's assets on accounts in order to safeguard the interest of the private creditor. However, in contrast to the maintenance regulation and the public EU law and convention areas, and then in particular the parts in EU law concerning cross-border recovery of tax and social security claims, which include provisions for an exchange of information for recovery purposes, there exists yet no corresponding solution in the cross-border area for enforcement matters related to the four regulations here concerned in the civil and commercial areas. As I may have mentioned yesterday, there is a Council Directive 2010/24/EU of the 16th March concerning mutual assistance for recovery of claims relating to taxes, duties and other measures, which will enter into force the 1st of January 2012. I would like to emphasize that the new provision in that directive does not any longer make it possible for a member state to refuse to leak information about money on bank accounts in the financial sector claiming bank security. Well, therefore, this situation needs to be more efficiently addressed, irrespectively of the amount of the claim, and be substantially further improved by reforms of EU law, based on the Council's programs with the aim to provide more efficient access to information for enforcement purposes in civil and commercial matters having cross-border implications in relation to the scope of application of the regulations here concerned. The need of efficient access to information has of course to be balanced against the interest of the debtor of humanity, dignity and privacy, including data protection. Access to information regarding the assets of the debtor for enforcement purposes calls for a balanced equilibrium between the creditor's right to efficient enforcement of his claim and the debtor's right to humanity and privacy in such situations. These rights can be derived from the European Convention on Human Rights. Arguments exist inter alia based on the interpretation of Article 6.1 of these European Conventions in favor of considering a demand of access to information for enforcement purposes an important requirement in order to make the execution of a judgment efficient. Also, it may be argued that efficiency in this context should mean a demand on the availability of all necessary information for enforcement purposes in order to safeguard the creditor's right of efficient enforcement, and by such means promote a realization of the creditor's claim in the assets of the debtor in the interest of his right of a peaceful enjoyment of his possessions according to Protocol 1, Article 1 of this European Convention. There exist strong arguments in favor of the principle to consider the availability of information for enforcement purposes related to the assets of the debtor at the enforcement and seizure of a creditor's claims to constitute a fundamental right based on Article 6.1 of this European Convention. Efficient access to information regarding the assets of the debtor must, however, be balanced against the rights to a treatment of humanity and dignity of the debtor, and in case of a coalition between these interests in favor of the latter. This access to information must also be balanced against the right to privacy of the debtor and be proportionate in relation to the need for needed information for enforcement and recovery purposes in order to avoid that the debtor is exposed to injuries as far as possible. Consequently, no more information should be available and used for the enforcement of a claim that corresponds to the necessary need for the purpose of efficient enforcement of the creditor's specific claim. In this way, only such a proportionate part of information should be made available which would contribute to avoid an excessive abuse of information related to the assets of the debtor and subsequently minimize the risk to injure the debtor. Access to information should also be acceptable and even beneficial to the debtors under the conditions that it is used in a balanced way for enforcement purposes, not by the creditor in person or by obscure private recovery agencies, but under the control of an independent, neutral third party, a regulated enforcement agent, who has the task of establishing this balanced equilibrium between the rights of the creditors and the debtors under the rules of law and the supervision of state bodies, courts, and authorities. Other important reasons that motivate why an improved access to information for enforcement purposes should be provided directly to the enforcement agents instead of to the private creditor are that these agents, at an application for the enforcement of a claim by the creditor, would anyway have to review and evaluate received information on assets of the debtor from the creditor as an integrated part of an actual enforcement procedure in a justified balance between the interest of efficiency of the private creditor and the interest of privacy of the debtor, which may or may not result in the attachment of assets indicated by the private creditor. In an overall evaluation of these reasons and conditions related to access to information for enforcement purposes, it becomes clear that the creditor's interest of efficiency is of a greater weight than that of the debtor's privacy. This does not, however, mean that this interest of the debtor may be ignored. There are good arguments in favor of that both new EU law and national legislations in the member states should be more influenced by this interest of efficiency. There's a part in my paper that I will not specifically address here. It's a suggestion made by Professor Berglund from the University of Heidelberg, and he has suggested that we should have perhaps a European Assets Declaration and also a European Garnishing Declaration. Well, I reject these proposals. I don't think they are so well founded, but I don't think I will, for reasons of time, consume a lot of time, so I think I will just drop it. And in case we have some more time, or you would like to know why I think so, I could get back to it later on. So I will just jump over to the conclusions in relation to the EU system for exchange of information. Well, my conclusions are in an overall evaluation that the maintenance regulation, which creates an optional right for a private creditor who holds a title of execution to make use of an exchange of information for enforcement purposes, is best suited to serve as a model to be adopted and developed to the corresponding needs of a private creditor for an exchange between the regulated enforcement agents of the member states in civil and commercial enforcement matters having cross-border implications. I've also suggested, for practical reasons, that such a reform work rather is conducted aiming to include the relevant provisions in one separate new EU regulation in support of the scope of the four EU regulations here concerned, than to enter such similar provisions in the four regulations. This is for the benefit of a higher degree of service and efficiency to the private creditor at the enforcement of his title of execution and for a proportionate treatment of exchange information and privacy in relation to the debtor. Also, it may be contemplated as a practical and efficient service measure available to the creditor that he should have an optional right, as already available under the maintenance regulation, to file an application related to a specific matter in the member state of origin of his title of execution. Normally there is where he has his domicile, for a following exchange of information for enforcement purposes with another member state. A request for information following the private creditor's application should, for reasons of efficiency and integrity, be transmitted electronically in a closed communication system between the member states, as speed is of essence. Well, this suggestion involves this suggestion of this new cooperation concept will, as any other possible alternative, give rise to the question about the financing of the increased costs created by the needed work. I think it remains to be discussed to what extent and proportion the private creditors, respectively the member states, should pay for the services made available under such a possible cooperation, and what possible fees creditors should pay or not pay to their national regulated enforcement agents for using their services in relation to this available option in a matter for the exchange of information for enforcement purposes. Also, it remains to be discussed how such a possible cooperation, which would include work in the member states for communications between the national designated competent authorities or contact points, and all the national regulated enforcement agents and the private creditors, best should be structured. These ideas conform with the objective of the Council's programs and would also promote the better functioning of the common internal market. So now I will try to move on to the third suggestion on my behalf, and that concerns this scary EU harmonization of national legislation, which of course only is possible, for example, in matters having cross-border implications or based on some other grounds of harmonization. Well, the establishment of, I suggest that there should be an establishment of a minimum level of harmonization of national legislations for access to information for enforcement purposes, and of a sufficiently efficient solution for access to information for enforcement purposes in civil and commercial enforcement matters having cross-border implications. And this is required in EU law to meet the objectives of the Council's conclusions and programs and the standards of the European Convention on Human Rights. The establishment of such a more equal level of access to information provided to the enforcement organs would guarantee a better efficiency of justice and a more equal treatment of creditors and debtors in the European judicial area. Consequently, the national differences of access to information for enforcement purposes would be reduced, and creditors who are able to present enforceable titles of executions under the 4 regulation here concerned at an application for their enforcement would then come into a more similar position to the creditors who hold national titles on the disclosure of assets in all enforcing member states. A harmonization of national legislation is also motivated and required in the interest of states to implement the Council of Europe's recommendation on enforcement, and by such means respond to the legal objectives of this recommendation. Such a harmonization corresponds, in addition, to the objective of the general state interest of a more efficient enforcement of claims in society and the interest of efficiency of the creditor. The Council of Europe has established the goals in its recommendation on enforcement. Those are: the debtors should provide up-to-date information about their income, assets, and on other relevant matters. The search and seizure of the debtor's assets should be made as efficient as possible, taking into account relevant human rights and data protection provisions in the Data Protection Directive. Also, there should be a fast and efficient collection of necessary information on the debtor's assets achieved through access to relevant information in registers and other sources, as well as the option for the debtor of making a declaration of his assets. Consequently, the Council of Europe's recommendation on enforcement may, in a longer perspective, contribute to alter the variety in national laws of the member states of the Council of Europe into more equal levels of access to information for enforcement purposes. Several authors have also emphasized the importance and confirmed the need for access to information for enforcement purposes based on various aspects, particularly in the civil enforcement law area, and including the twofold objectives to increase access to national information and to establish a multilateral cooperation system between states for the exchange of nationally available information. In order to obtain all these objectives of improved access to information for enforcement purposes of judgments to enforcement organs in the civil enforcement law area, a harmonization in EU law of national legislation under the option of any national system should stipulate the goals of an efficient and up-to-date access to information to enforcement organs for enforcement purposes of judgments achieved preferably by electronic means, through access to relevant information in registers and other sources of information regarding the debtor. The establishment of a sufficiently efficient solution for access to information for enforcement purposes in the cross-border civil enforcement law area would also have to take into consideration a sufficiently harmonized level of access to information for enforcement purposes to regulated enforcement agents in national laws in order to guarantee at least some kind of mutually equal, acceptable level of exchange of information which could be used for the benefit of cross-border enforcement of a private creditor's claim within the EU. This means that any attempt to improve efficiency by access to information for enforcement purposes in the cross-border context would also have to consider the establishment of a sufficiently high level of access to national information. And I will now come to my conclusions about this third final suggestion. In order to achieve harmonization through EU law in relation to matters having cross-border implications, detailed provisions for a harmonization of national legislations should be stipulated under the option of any national system of regulated enforcement agents. It would be an advantage if such provisions could be entered into the same new regulation as suggested earlier by me for exchange of information for enforcement purposes. National legislations should preferably provide an efficient and up-to-date access of information to enforcement organs for enforcement purposes and titles of execution related to civil and commercial law claims in order to secure access to information about the debtor's address or place of location, employer or business, through corporate register or other sources of income, including private or social insurance institutions, incomes and other assets in his possession, ex gratia through debtors' registers kept by such officials, declaration of his assets made to the enforcement agents or in court, and status of indebtedness or insolvency, that is, bankruptcy or other collective solvency procedures. This access to information should preferably be achieved through electronic means. Some final words. Well, finally, I think we are on our way, but certainly further efforts are needed and has to be given priority in this context in order to increase access to justice in the internal market of the EU. Well, dear colleagues, thank you for your attention.